Hello, everybody. Hi, Attorney Sharif. How are you?
Hello. Hi, Mary. How are you doing?
Doing very well, and I'm very much excited. I'm sure many of our friends, our clients, and our viewers all over the world are very excited to know about today's topic. So let's get started. Today is all about critical salary criteria updates that everybody's got to know. So, Attorney Sharif?
Sure. Before I share the critical salary criteria update, I just want to do a little bit of a kind of general review of what we're talking about here because, we often assume that folks are kind of entrenched in this, EB1A situation, but, there's a lot of people that are coming just, new to the process. So I just want to kind of maybe circle back a bit because as we look at the dates of availability for adjustment of status or filing for a visa, you're having a lot of individuals who are in that upper echelon of professional pursuits, who maybe are from Europe, some of the non basically, traditionally we were looking at a lot of demand in EB1 category for India and China. But as even now EB2 is backlogged, we're starting to see interest from a lot of folks from different countries. So I want to do a small overview. And that is to say that there are essentially three major categories in the employment-based classifications. And among those three categories, employers usually sponsor folks in either EB3 or EB2 category, right? Employment-based second or third category. And with that, you will find that there will be backlogs, meaning that there's a significant wait time for individuals to adjust their status or acquire a visa based on any of those EB2 or EB3 employer-sponsored categories. Therefore, many individuals are looking to see how can I expedite that process and find a faster pathway to a green card. And therein lies the EB1A, because the EB1A is a self-petition, first category classification for an individual who has extraordinary ability. Now, what extraordinary ability means is somewhat open for discussion. And what we like to do is, rather than make assumptions or kind of repeat language that we find in various websites like even USCIS's website, I like to take a statutory approach. That is to look at the law and determine what exactly is going on. So you have a statute that's developed by Congress and eventually signed by the president. It becomes a law. Now what happens is you have a regulatory agency. You have USCIS who interprets that statute, creates regulations to determine how the adjudication process will unfold, right? So there are updates to regulations from time to time, and there is one such update that took place on September 12th that we're going to tell you about in a moment. But you also have to understand, so those of you who are relatively new to the process are thinking about an EB1A, essentially what an EB1A is about is you have to demonstrate that you meet three specific requirements under the law. That is, number one, that you have demonstrated that you have already achieved sustained national or international acclaim that is recognized in your field of endeavor. Sustained acclaim recognized in your field of endeavor. Secondly, that you will prospectively benefit the United States, that you are going to bring about future benefit to the US. And the third requirement is that you will continue to work in your field of endeavor. You'll continue to work in the area where you have been recognized as having a claim and extraordinary ability. So essentially what we're trying to convey here is that in order to understand whether or not one is able to apply under the EB1A category, it's not a black or white issue. There's a lot of gray there. And it's really important for you to consult with somebody that understands the nuance here and can sort of, determine or, come to a better understanding for you in terms of what your requirements are. There are a lot of highly talented people who are in some of the Russia, for example, former Soviet states, who are STEM related, off the chart in terms of STEM related capabilities. And they're asking about this situation. People, for example, from Turkey, from Europe, all over. So I would just encourage everyone, including our Indian and Chinese friends, that you have to look at the overall picture. You cannot just focus only on what you heard or read in a particular place, because there's a lot of nuance there, and there's a lot of different ways to kind of pursue this. So within these requirements that I just mentioned, within those 3 requirements, one of those requirements is that you have achieved sustained national or international acclaim that is recognized in your field of endeavor. Now, the way that you demonstrate sustained acclaim is to meet a minimum of 3 of 10 criteria that USCIS has laid out. Now, so among those criteria is that one demonstrate that he or she commands a high salary in relation to her peers in the field. So the entire statutory language is that you command a high salary in relation to your peers in the field. So I often am asked a question, I make X number of dollars, does this qualify as high salary? And that is not the right question to ask, because there are many, many variables at play here. For example, if somebody's working in a governmental sort of role, then the peer comparison would be much different than if they were working in the private sector. If someone is working in a nonprofit organization, then the comparative analysis might be different. So there's a lot of nuance here that we need to consider before you just make a blanket statement. Do you qualify or do you not qualify? So this is more art than science, I think. But I think, do you have any follow-up questions on that, or should I share what I wanted to share?
You can share it already, please, Reef. Although there is a lot, but yeah, I think
Go ahead. Let's ask a question, and then we'll share it.
So like you mentioned 3, right? Because sometimes, like many of our clients, right, especially those who have yet to consult with us, they're just asking about the 3 criteria. Like they keep asking, can Sharif do 3, 5? How many of the criteria is he gonna do? So I mean, like, what would be your advice to people that, of course, you have to focus on the criteria, but then it's more than just the 3 criteria that you have to satisfy, right? With regards to an EB1A.
Absolutely, yeah. So what I actually believe in is not so much that it's more than the 3 criteria or less than the 3 criteria, but I think that in order to really determine if one qualifies for EB1A or can qualify for EB1A, it's really a matter of whether they are able to demonstrate that they've reached a very high level of achievement within a narrow and specific field of endeavor. So I don't necessarily subscribe to the idea that we have to determine what 3 criteria we're going to do before we get started, because really there's some criteria that you can develop if you give yourself a little bit of time. So really what the criteria should be about is that it's a vehicle. The criteria is an opportunity or a vehicle to demonstrate to the adjudicating officer that you are of a particular caliber. What I mean by that is, for example, one of the well-known criteria is that an individual performs in a critical or leading role for an organization of distinguished reputation. So in order to demonstrate whether or not you've performed in a critical or leading role for an organization of distinguished reputation, we need to think about, why does USCIS even care about this, right? Because let's say that, for example, I perform or one performs in a as the CTO of a software company, right? So clearly, being a CTO, Chief Technology Officer, is a leading role in the company, right? So you'd think that's a very strong attribute that one can use to apply for EB1A. But what happens if this software company is actually a 2-person organization that was organized in someone's basement and has never had a client and has never generated any revenue, has never sold a product, doesn't even barely has a website, right? So they don't have any reputation. So when you think about the actual criteria, you understand that, look, really, what does the criteria say about you? So if you're at a high level, if you have performed in a critical role for an organization that has a distinguished reputation, then the meaning of a distinguished reputation, trusting you to undertake activity that is critical to the outcome of the organization's activities, that translates into not only meeting a criteria, but in demonstrating that you are among the foremost experts in the field, such that a distinguished organization has trusted you, of all people, to undertake this highly critical work. So the question is not how many criteria. The question is, what does the criteria say about you? That's the question.
That was beautiful. That makes a lot of sense. Thank you, Attorney Sharif.
Absolutely.
And then you said you're going to share something?
Yes. So I'm sharing here our latest updates with regard to the regulatory criteria. So if those of you who do not know, the USCIS has a policy manual that exists, and essentially you are able to kind of access this policy manual. It gives you a lot of detail about what the adjudicators tend to look for. And just so you know, so if we look at here under updates, this says here on September 12th, 2013, there was an update. So basically, you know that this information is new, right? So basically, you know, it gives a lot of different information. And I'm just going to kind of go down quickly, but really quick, I just want to, in case you guys don't believe me, that there are 3 statutory requirements right here, right? You have 3 requirements: sustained a claim, that you will continue to work in your area of expertise, and that you are going to substantially benefit the United States, right? So without those 3 requirements, you're not going to succeed. Anyway, so I'm going to talk about the updates with regard to the salary criteria, because I feel this is a very, very important change that does open up a significant opportunity for many people to apply for EB1A. If we look at the history of adjudication practice by USCIS over the past decade, what we're going to find in almost every instance is that the USCIS has used the either a W-2 or proof of already existing or proof of already earned income as a basis for salary. So whenever, for example, one presented salary as being prospective or future looking, it was always pushed back against. And although my argument was always that the language of the statute states that one command a high salary. So if you look at the plain language, command a high salary, and in fact, where we had the most success with this was actually during the Trump administration. Because during the Trump administration, the government sought to be very strict about the language. So they would take this very strict construction of plain language of the statute. And what we had pointed out at that time was that the plain language of the statute does not say that you earn a high salary. The plain language, or that you have earned a high salary. The plain language of the statute actually says that one must command a high salary in relation to their peers. And of course, that takes into account geographic considerations. So if one is working in Arkansas, the comparative basis for salary is far different than if one is working in San Francisco. So we always want to look at the geographic comparison to the extent it could benefit the client's case. But critically, the idea of prospective salary was always something that was elusive, particularly in the last couple of years. So now what has happened is finally the USCIS has allowed some clarification on this matter. So if we are to read here, it says USCIS determines whether a person's salary or remuneration is high relative to the compensation paid to others working in the field. So it's a comparative basis. USCIS does not interpret the phrase has commanded to mean that the person must have already earned such a salary or remuneration in order to meet the criteria. That is new language. Okay, so I'm going to repeat that right here. USCIS does not interpret the phrase has commanded to mean that the person must have already earned such a salary in order to meet the criteria. This is it's hidden language. Not a lot of people are noticing it. In my view, this is one of the biggest, most important updates to the regulatory criteria that has taken place in the past several years. This is enormously important. This means that an individual seeking to apply for EB1A can demonstrate that they command a high salary based upon job offers from organizations that they have not yet even joined, right? Because if we look at evidence relevant to demonstrating high salary, it includes right here, job offer letter.
Okay, I see that. Okay.
Right? So other evidence of prospective salary. Prospective salary. This is enormously consequential for folks. So, I think that it's really, a huge benefit for anybody that is thinking about seeking an EB1A route to now do so under these new guidelines, because I think that this really opens up opportunity for many individuals and many companies out there that want to kind of find a way to retain folks and help them on their path to a green card. This is definitely a very, very important update that is going to make a huge impact on folks' lives. So I would ask anybody that's interested, and we could end the sharing, but I would say that anyone who's interested in sort of removing themselves from this kind of endless backlog and take matters into your own hands, I think this is another important reason why you should do so. So we have already implemented this change in our work over the past month in terms of what kind of evidence we're looking for and establishing. And I think that it's really just a very good news for a lot of people with regard to the updates. A lot of folks, I hear a lot of complaints about the updates to the adjudication guidelines. I mean, I'm seeing the cup half full, because I like to just look for what actually is going to help our clients. I don't have time to complain and talk about how wicked USCIS is. I mean, honestly, if we're honest about it, we just need to find a way to help support and benefit our clients. Of course, the backlog issue is a completely separate issue. That's not a USCIS problem. That's a governmental problem in terms of whether they're going to change the basically country quota backlog. It's been introduced again. It's been introduced every single year. It never really reaches a point where it's passed as a law. But again, and even in the past, whenever we've seen them, it's been several years before it actually is implemented. But here, I think you have a silver lining of being able to demonstrate that you can actually show salary based on prospective earnings rather than what you've already earned. So, that's a very, very important update, and one that I think is going to be enormously beneficial to many, many people out there.
Yes. So I think do we have a few comments, Sharif, before we go?
I think people are just saying hi, and hello and sending comments. So that's fine. I don't think we really need to jump into it too much. I just want to give that quick update, if that's okay. And then if we are maybe going to, follow up with folks, they can, know where to contact us, and we can, reach out to them that way.
Yes, and of course, we encourage everybody to please schedule your consultation right now. Like what Attorney Sharif mentioned, it's not really, just a science; it's more of an art. And of course, we're here to help you find ways on how you can also pursue your green card, your American dream. So thank you so much. I think you can see where you can find us. So info@silmilaw.com and visit www.silmilaw.com. Thank you so much. Anything else, Attorney Sharif, before we go?
No, thank you, Mary. As always, wonderful to connect with you, and hopefully we'll talk again soon and get more good information out there to the people.
Yes, thank you. We'll see you guys again in our next live. Bye.
Thank you. Bye bye.